Dear learners, good day. In this module, we will be discussing the National Human Rights Commission and various other commissions. An overview. We all are aware of the National Human Rights Commission, which is by far the most important national commission in India. The National Human Rights Commission was established through the Protection of Human Rights Act of 1993. It is the apex human rights institution in India. It is important to note that India's NHRC is fully compliant and was established pursuant to the Paris Principles, and it has been accredited with the A status by the International Coordinating Committee for National Human Rights Commissions (NHRIs). It is pursuant to these Paris Principles that the structure, functioning, and the role of the National Human Rights Commission has been cast. As we've already understood, there are various other commissions as well. For example, the Constitution speaks of the Election Commission. But this aspect of national commissions are quite distinct. When we speak of national commissions, we are speaking of particular groups who are vulnerable, who are socially marginalized, who have been subjected to stigma and human rights violation, who require upliftment through the active encouragement of all facets of society. The National Human Rights Commission is one such body, and it is statutory in nature. It is important to understand that though there are many national commissions, not all of them are statutory and not all of them are constitutional. So broadly speaking, when we classify national commissions or national bodies, it can be classified under three heads. The first is those commissions or bodies that are given constitutional sanction. As on date, we have the National Commission for Scheduled Castes, the National Commission for Scheduled Tribes, and the National Commission for Backward Classes, NCSC, NCST, and NSBC. These three commissions are the commissions that have been guaranteed legal sanctity through the Constitution in itself. There are specific and explicit constitutional provisions that create, lay down, and provide for the various functions, roles, and responsibilities of the National Commission for Scheduled Castes, Scheduled Tribes, and Backward Classes, respectively. On the other hand, we have several statutory commissions. By way of statutory commission, what we mean is that a particular commission has been created through a statute or a legislation and has statutory backing, pure and simple. The National Human Rights Commission is one such example, which has been created through the Protection of Human Rights Act of 1993. Parallelly, we have commissions such as the National Commission for Protection of Child Rights (NCPCR) and the National Commission for Women, the National Commission for Minorities, the National Commission, or rather the Chairperson for the Persons with Disabilities, the Commissioner for Persons with Disabilities, so on and so forth. So all of these institutions or offices or commissions have been given legal sanctity through an ordinary legislation. Apart from this, there are certain commissions which are quasi-judicial or quasi-authoritative in nature. A typical example would be the National Commission for Safai Karamcharis that work for the protection of people who are engaged in sanitation work. Though they are acting as a forum, they are neither having constitutional nor statutory backing explicitly. And various other commissions exists in terms of the constitution, but for our discussion we are limiting ourselves to these specific entities that focus on the human rights of specific groups or the protection and welfare of vulnerable communities. So moving ahead, we will be discussing first and foremost the National Human Rights Commission, the composition of the National Human Rights Commission. It is important to understand that the commission in itself comprises of a chairperson as well as 6 full-time members and 7 deemed members, right? So apart from this, we will be discussing what is the detailed composition of the entirety of the National Human Rights Commission. So as we already understand, we know that the composition, the head of the National Human Rights Commission is a judge. Earlier it was only a Chief Justice of the Supreme Court who is retired who was permitted to hold the position of the chairperson of the NHRC. But subsequently it has been amended, and any person who is retired as a judge of the Supreme Court, not necessarily as the Chief Justice, is entitled to hold chairmanship of the National Human Rights Commission. Apart from this, there is also a composition for a Chief Justice of the High Court. Apart from that, there are 3 members who are having expertise and who have practical experience in working for human rights. Parallelly, a judge of the Supreme Court is also appointed for this composition as a member of the NHRC. Next comes the aspect of deemed members. Apart from these full-time members, there is also the aspect of deemed members. So deemed members are chairpersons or representatives of other national commissions who are given a place within the fold of the National Human Rights Commission. It begins with the chairperson for the National Commission for Minorities. A chairperson of the National Commission for Minorities is a deemed member within the NHRC framework. Parallelly, the chairperson of the National Commission for Scheduled Castes, the chairperson of the National Commission for Scheduled Tribes, the chairperson of the National Commission for Women. They are also given representation as deemed members within the NHRC framework. In the year 2019, the incumbent government expanded the scope of deemed members and added on furthermore members within the fold of the NHRC deemed membership status, with the chairperson of the National Commission for Backward Classes, the chairperson of the National Commission for Protection of Child Rights (NCPCR), and the Commissioner for Persons with Disabilities also being given representation within the NHRC framework as deemed members. So essentially, as on date, there are 7 broad chairpersons of various other national commissions who are given the status as deemed members, which includes the NCM, National Commission for Minorities, NCSC, NCST, NCOBC, National Commission for Women, the National Commission for Protection of Child Rights, and last but not the least, the Commissioner for Persons with Disabilities. Each of them representing a specific vulnerable group who deserve special protection, care, and the long arm of the law. The case being minorities, scheduled castes, scheduled tribes, women, backward classes, children, and persons with disabilities. So the human rights of all of these people with all the other members of society is the ultimate goal of the National Human Rights Commission. Now coming to the appointment of the chairperson and members. It is important to note that the National Human Rights Commission is appointed by a high-powered committee which is headed by the Prime Minister, who is the chairperson. It is this committee that would be making recommendations for appointment for the position of the chairperson of the NHRC. It comprises of the Prime Minister, who would serve as the chairperson of this committee. It would be comprising of other members, which include the Speaker of the Lok Sabha, that is the House of the People, the Home Minister, the incumbent Home Minister of the Government of India, the Leader of Opposition of the Rajya Sabha, that is the Council of States, the Leader of Opposition in the Lok Sabha, that is the House of the People, and last but not the least, the Deputy Chairperson of the Rajya Sabha, that is the Council of States. So it is this body comprising of Prime Ministers and various other members of the legislature, particularly holding high constitutional offices such as Speaker, Deputy Chairman, Leaders of Opposition, Home Minister. It is these people who appoint the member or the chairperson of the NHRC. Moving ahead, we have to understand the functioning, the role, the mandate of the National Human Rights Commission. First and foremost, when we speak of the National Human Rights Commission, as the name itself indicates, its function goes on to the protection of human rights. It is the function of the National Human Rights Commission to inquire, either based on a petition presented to it or suo motu, by a victim or any other person in respect of violation of human rights or abetment of violation of human rights, or negligence in the prevention of violations of human rights by a public servant. So very often we see that the NHRC takes notice, suo motu or based on a complaint filed before it, on violations of human rights that happen in and around our society. Parallelly, it also intervenes. It adds itself as a member, as a party to the proceedings involve allegations of violations of human rights before courts. Whenever there is a serious matter concerning violation of human rights, then the Supreme Court very often asks the opinion of the NHRC, and NHRC voluntarily adds itself as a party and represents its point of view before the court. And apart from this, there are various other important functions that there exists in respect of the aspect of the NHRC. That is, first and foremost, when we speak of vulnerable groups, right? So when we speak of various government institutions that there exists in the form of homes wherein inmates are lodged, the NHRC is free to review, inspect and make sure that the treatment of those people, it may be in the form of welfare homes, it may be in the forms of prisons, it may be in the form of any other such homes or places that are run by the government wherein people are lodged, to ensure that they are properly protected and that the human rights are not violated. It is the duty of the NHRC to do so. And apart from that, they frequently undertake studies of reviews of constitutional safeguards as well as international human rights frameworks. So what are the existing constitutional frameworks, how far is it protected, and what can be done in order to improve the protection for human rights under the Indian Constitution as well as under international frameworks to which India is a party to. Apart from that, it also reviews various factors that serve as a bottleneck, that serve as a challenge in the implementation of human rights. What are the factors that contribute to or hinder the progression of human rights, including terrorism, so on and so forth? They study and they give their opinion on. Parallelly, we see that they study international instruments on human rights, the UDHR, the ICCPR, ICSCR, various UNGA resolutions, and anything and everything that is within the purview of human rights law in an international forum. It is the duty of this NHRC, or it is rather the mandate of the NHRC, to discuss or deliberate on such mechanisms and in order to disseminate the same. And last but not the least, there is the aspect of promotion of research. Very often we see that the NHRC funds legal research as well as various other socio-legal research concerning the protection of human rights, including funding it. Apart from this, the spreading of human rights literacy, taking human rights to the nook and corner of the country to ensure that all segments of our population, particularly the vulnerable and marginalized sections of society, through various initiatives, endeavors as well as publications through print, social and other forms of mass media, is an important function of the NHRC. Apart from this, it also involves itself with various non-governmental organizations that work for the upliftment or the protection of various vulnerable groups as well as human rights entities, NGOs, in order to promote the development of human rights on a broad sphere. These are some of the important functions that there exists when we speak of Section 12 of the Protection of Human Rights Act. Moving ahead, what are the major landmark cases wherein the NHRC took up the matter, and what role did it play in the protection of human rights of various vulnerable groups? Before we begin our discussion on these landmark cases, it is important to note that the role of the NHRC no doubt is important, no doubt is significant, but nevertheless it is purely recommendatory in nature. Unlike judicial forums, the decisions of the Supreme Court, the High Courts, any decision or order made by the NHRC that is not binding upon the government, nevertheless in 9 out of 10 cases, the government relents and hands over compensation or takes action as directed by the NHRC. And apart from that, there are specific segments or sects which are beyond the scope of the NHRC in terms of its power to investigate. So with that caveat, we will proceed on our discussion on landmark cases of the NHRC. One of the most important cases concerning the role played by NHRC was the Gujarat riots case. In the aftermath of the setting up of the NHRC, the first major riots that happened in India was the 2002 Gujarat riots, and in the backdrop of those riots, the National Human Rights Commission approached the Supreme Court, intervened on behalf of the minority community there exists, and it initiated various measures to alleviate the suffering as well as to ensure that these aspects do not recur in future. Another parallelly important case is the Punjab mass cremation case. In the backdrop of insurgencies and various other unlawful activities that were happening in the backdrop of the extremist movement in Punjab, several groups of people were subjected to persecution and human rights violations, and the state machinery, including the police force, were involved in large-scale mass cremation of unidentified bodies, so whose whereabouts were not known, whose cause of death was uncertain. So in this case, the National Human Rights Commission also played an important role in providing compensation for victims of this mass cremation and the family members to the tune of 1.75 lakh rupees. And following this, there was the case pertaining to starvation deaths in Orissa, and based upon the special rapporteur for relief and rehabilitation in consonance with the NHRC, several measures were taken to prevent the recurrence of such starvation deaths within the state of Orissa. And apart from this, one of the important areas of the NHRC is to deal with extrajudicial killings, particularly by the police force. In terms of the encounter deaths in Andhra Pradesh, in the year 1997, the National Human Rights Commission formulated guidelines for encounter deaths for its reduction, and in order to investigate and to prevent frequent happenings of encounter deaths and to put an end to extrajudicial killings. And last but not the least, in respect of environmental and human rights cross-pollination concerns, there were cases concerning death due to silicosis, wherein several vulnerable tribal member groups who were involved in quartz crushing industry in various parts of India, they were afflicted by an occupational disease in the form of silicosis, and the NHRC played an important role by its intervention to put an end to the suffering of these vulnerable tribal groups who were subjected to medical ailments as a backdrop of unsafe working conditions, and it also ensured the payment of compensation to their family members and to the victims. So these are some of the many important landmark cases wherein the Supreme Court, or rather the National Human Rights Commission, has played an important role in ensuring the protection of the rights of the people, the human rights of the people. So moving ahead, what are the other important commissions? We will be discussing briefly the role of the National Commission for Women. So the National Commission for Women is created through the National Commission for Women Act of 1990, but actually it was established on 31st of January 1992. So the backdrop of setting up of such a commission is traced to the writings or the recommendations of the Committee on the Status of Women in the year 1971. In developing and underdeveloped countries, particularly in the form of third world countries, including India, there is the element of gender imparity. There is gender discrimination, and there is large scale harassment as well as human rights violation that happens against women. With a view to protect these vulnerable group in the form of women, in accordance with Article 15 Clause 3 of the Constitution, the mechanism for the National Commission for Women was set up. The objective was to facilitate the redressal of grievances of women and also to accelerate the socio-economic development of women. So the first chairperson of the National Commission for Women was Jayanti Patnaik, and following this there have been several commissioners who have played an important role in the protection of the rights of women through the aegis of the National Commission for Women. So what is the mission or the goal and the vision of the National Commission for Women? So as specified by the National Commission for Women in itself, the objective of the National Commission for Women is to ensure and to strive towards equality and equal participation in all spheres of life by securing the due rights and entitlements of women. How are we going to do this? Through suitable policy formulations, by changing or formulating policy interventions, through legislative measures, formulating laws, legal mechanisms and responses, and effective enforcement of laws. Very often we see laws exist on paper but they lack enforcement. Effective enforcement of laws and implementation of welfare schemes and policies targeted at women, and apart from that, devising strategies for the solution of specific problems or situations that women have to face, which makes them the subject of discrimination and atrocities. So the objective being this, what is the vision of the National Commission for Women? Their vision, as proclaimed by themselves, is to ensure that the Indian woman is secure in her home and outside and is fully empowered to access all her rights and entitlements with opportunity to contribute equally in all walks of life. That being the vision and mission of the National Commission for Women, what is the composition of the National Commission for Women? Essentially, the functioning, the style, the composition is quite similar to the National Human Rights Commission. It is just that there is an added impetus on the role of women within the National Commission with other vulnerable groups. So first things first, just like the NHRC, the National Commission for Women is also headed by a chairperson, and it is usually headed by a woman, no doubt, and there are 5 other members who are nominated by the central government who have ability, integrity and standing, or who are experienced in law, trade unionism, management and industry, particularly in respect of protection of women, women's rights, either through voluntary organizations or in various aspects of women's welfare, economic development, health, education, so on and so forth. So essentially, people who are involved in all of these facets, they can be nominated by the central government directly for this National Commission for Women. And apart from this, apart from women being given a representation, within the National Commission for Women fold, there is a representation for a member of the scheduled castes and the scheduled tribes respectively. So there is a scope for a member of the scheduled caste and scheduled tribe to get representation within the National Commission for Women. And they are assisted, the National Commission for Women is assisted by a member secretary who is nominated by the central government, who is usually a civil servant who has an important role to play in the conduct of the affairs of the National Commission for Women. What are the roles, powers and functions of the National Commission for Women? Broadly speaking, it is laid down under various sections, some of which we will be discussing. Section 8, which talks about power to appoint committees to deal with specific issues concerning women. Section 9, which is the power to regulate its own procedure. Section 10, which is akin to Section 12 of the Protection of Human Rights Act of 1993, which deals with the function of the National Commission for Women. Section 12, which enables the central government to give grants to run the National Commission for Women, and 16, which mandates that the central government consult the NCW on all major policy matters affecting women. So this is one of the important roles of these national commissions. So the way in which these commissions are set up, so whenever there is a matter pertaining to a human right violation or that has a impact or it impinges upon human rights, it is no doubt the duty of the state, the government, to consult the National Human Rights Commission. Same is the case for all of these national commission. When there is an issue concerning minorities, consult the National Commission for Minorities. When it is women, National Commission for Women. If it is SCs, National Commission for Scheduled Castes. If it is STs, the National Commission for Scheduled Tribes. If it is children, NCPCR. So very often you can see that all of these entities, they add themselves in various proceedings and matters concerning each of these specific vulnerable groups. So this is not just limited to the National Human Rights Commission. Whenever the case pertains to disability rights, the Commissioner for Persons with Disabilities will be implemented. He will be asked to give his opinion. So this is how the entire mechanism of commission system works in India to protect all of these vulnerable groups, so that they are heard, that a voice is given to all of these vulnerable groups whenever major policy decisions are taken concerning each of these different vulnerable groups. So moving ahead, under section 10, what is the function of the National Commission for Women? That is what we will be discussing. Similar to the National Human Rights Commission, the function extends to investigating the safeguards for women under the Constitution and under various other laws. For example, we have the protection of Women from Sexual Harassment Act. We have POSCO Act 2013, which protects minors from sexual offences. We have various other welfare measures, the Maternity Benefit Act, so on and so forth. There are both protective criminal enactments that penalize crimes or aim to protect women, and at the same time protective legislations that safeguard or give an extended lifeline or a cushion to protect women. So both of these fall within the purview of Article 15 Clause 3 of the Indian Constitution. And apart from that, the duty extends to presenting reports to the central government and to various other commissions. As I already said, the National Commission would be in close consonance with the National Human Rights Commission, so on and so forth. So there is a sense of cross-pollination, a symbiosis between various entities in the form of national commissions as against each other. And the third is a recommendatory function, wherein they play an important role in recommending or giving suggestions to the government, both the union and the state government, for the protection of women and for the improvement of their way of life or the conditions of life, and also to review constitutional safeguards. This is akin to the NHRC mandate under Article 12 of the Constitution, not the Article 12, Section 12 of the NHRC Act. Apart from that, they also take up cases of violation of the provision of the Constitution. Parallelly, they also look into complaints, the power to look into complaints and issue suo motu notice to various people who are involved in deprivation of women's rights, and also in situations of non-implementation of protective measures, non-compliance of policy decisions. In all of these matters, the NCW plays an important role. They also undertake special studies on particular problems that are afflicting women and prevent their progression in life and society, particularly in the form of special studies and investigations which identify the root causes of discrimination and atrocities against the women, and what are the bottlenecks, the challenges or the glass ceilings that exists in terms of women and their upliftment. This is also a function of the National Commission for Women. Apart from that, they are involved in educational research by and large akin to the NHRC to ensure and identify factors that afflict women in their development, including lack of access to housing, basic health services, inadequate support, occupational hazards, so on and so forth. And apart from that, what is the role of planning in terms of protection of women and progression amongst the union and the states. Very often we say certain states are well developed in terms of protection of women. In all terms of social indicators, certain states do well. The sex ratio is better in certain states, whereas in certain other states the situation is just the opposite, right? So in order to ensure that all of this is evened out and that the progression of women is spread uniformly across the nation and that we are marching in one direction, what needs to be done, all that is also provided for as a function of the National Commission for Women. And apart from that, they can inspect jails, remand homes, women's institutions, any place where a woman is kept in custody either as a prisoner or as a inmate, either as a hospital or an observation home or a hostel for women that's run by the government by and large, to ensure that they're treated properly and protected. This inspection and supervision function is given to the National Commission for Women, and it is also empowered to fund litigation when there is a matter pertaining to large body of women, that is funding public interest litigations in respect of women's rights. That is an important function, and apart from that, they also place various reports before the Parliament in terms of what could be done. They place their recommendations and seek their acceptance for the same, right? And the same is done both at the state level. What can be done in order to ensure that the due position of women is properly achieved. Parallelly, we can also see that the National Commission for Women is also empowered with the status of that of a civil court in respect of its power to deal with or look into complaints and deal with matters concerning violation of rights of women. So all the powers of a civil court that are enjoyed is parallelly vested in the hands of the National Commission for Women. So this by and large winds up our discussion on the National Commission for Women, and as we already have seen, the National Commission for Scheduled Castes, Scheduled Tribes and the National Commission for Backward Classes. As I already said, these three were specifically targeted at caste-based groups that have been subjected to historical discrimination and injustice, first being the National Commission for Scheduled Castes and Scheduled Tribes. Under the original constitutional framework, there was no such separation between the National Commission for Scheduled Castes and Scheduled Tribes. They were fused, merged into one entity that was subsequently changed or separated by virtue of Article 338 and 338A. So 338 deals with the National Commission for Scheduled Castes and 338A deals with the National Commission for Scheduled Tribes. Subsequently, the incumbent government decided that it is appropriate to give the same measure of protection by conferring constitutional status for the backward classes as well, and hence the constitution was amended, placing the National Commission for Backward Classes within the meaning of Article 338 Clause B, thereby giving a constitutional sanctity to the National Commission for Backward Classes as well. So essentially the role, the function of all of these commission is to ensure that whenever there is a question pertaining to the upliftment, to the protection of these respective communities, the scheduled castes, the scheduled tribes and the backward classes. Of course, when we speak of the scheduled castes and scheduled tribes, their concerns, their problems are quite different from that of the backward classes, but the common thread being that the lack of social and educational upliftment with the added touch of untouchability and social stigma that afflicts members of the scheduled castes and the scheduled tribes, which is by and large not prevalent in the case of the backward classes. But the essential point to be noted is that whenever the government, as we already discussed, is intending to make up or take up any measure that has an effect or an impact either positively or negatively upon the rights of the members of the scheduled caste community, scheduled tribe community or the backward classes, it is required to consult with all of these bodies and get their opinion and before proceeding as such. So the common thread that runs between all of these organizations or commissions is that they are given sanctity legally or constitutionally, and that they play a very important role in protecting the rights of the respective groups. But at the end of the day, by and large, they continue to remain under the thumb of the government, though we say that the National Human Rights Commission is an independent body, same is the case for various other commissions as well. Their function is recommendatory in nature. Very often it is the complaint of human rights activists and members of civil society that the NHRC and various other bodies are in the nature of a toothless tiger. But nevertheless, they are on paper existing and they continue to play a role. So in that broader sense of achievement, we can continue to progress, looking into what can be done and what ought to be done in order to ensure the efficacy and the efficiency of such organizations. So by and large, that winds up our discussion on NHRC and various other commissions as part of this module. I will be seeing you in the next module. Thank you.